as aforesaid, in exercise of the power vested in me by Section 44, 1A and Section 44, 4C of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Deborah McPhee, as aforesaid, a member in exercise of the power temporarily vested in me with effect by Section 14th November 1 Tobago, given under my hand and the seal of the President of the Republic of Trinidad and Tobago, at the office of the President, St. Anne's, this 13th day of November, 2025. Honorable Senators, Senators are required to take the oath of office. Could we all stand?
I, John Heath, SC, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
I, Dr. Deborah McPhee, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
Put your mobile on silent. Honorable Senators, I'm awaiting two further instruments from Her Excellency. As soon as those instruments arrive, we shall in fact take the necessary steps to have the senators in question take their oath of office. So I crave your indulgence at the appropriate time.
Papers.
The Minister of Planning, Economic Affairs and Development, and the Minister in the Ministry of Finance.
Mr. President, I have the honor to lay on the table the following papers as listed on the order paper in the name of the Minister of Finance. The report of the Auditor General of the Republic of Trinidad and Tobago on the statement of recovery and expenses of the Ministry of Energy and Energy Industries for the year ended December 31st, 2024. The annual audited financial statements of the Export-Import Bank of Trinidad and Tobago for year ended December 31st, 2024. The annual administrative report of the Ministry of Finance for the fiscal year 2021-2022, and the annual administrative report of the National Investment Fund Holding Company Limited for the year ended December 31st, 2024.
Minister of Tertiary Education and Skills Training.
Mr. President, I have the honor to lay on the table the following papers as listed in the order paper in my name: the annual administrative report of the National Trade Agency for the year 2022 to 2023, and the annual administrative report of the Accreditation Council of Trinidad and Tobago for the fiscal year 2023 to 2024.
Mr. President, I have the honor to lay on the table the following papers as listed on the order paper in my name: the annual report of the Police Service Commission for the year 2024, and the annual report of the Teaching Service Commission for the year 2024.
Leader of Government Business.
Mr. President, I have the honor to lay on the table the following papers as listed on the order paper in the names of the Minister of Trade, Investment and Tourism and the Minister of Homeland Security. Firstly, the annual administrative report of the National Flour Mills Limited for the year ended December 31st, 2024, and the annual administrative reports of the Ministry of National Security for the fiscal years 2018 to 19, 2019 to 2020, 2020 to 2021, 2021 to 2022, and 2022 to 2023.
Thank you. Honorable Senators, I'd like to revert to the matter I brought to your attention earlier. By Her Excellency Christine Carla Kangulu, ORTT, President of the Republic of Trinidad and Tobago, and Commander-in-Chief of the Armed Forces, to Mr. Ashworth Jack. Whereas Senator the Honorable Satyakama Maharaj is incapable of performing his duties as a senator by reason of his absence from Trinidad and Tobago, now therefore I, Christine Carla Kangulu, President as aforesaid, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(a) of the Constitution of the Republic of Trinidad and Tobago, acting in accordance with the advice of the Prime Minister, do hereby appoint you, Ashworth Jack, to be a member of the Senate temporarily with effect from the 14th November 2025 and continuing during the absence from Trinidad and Tobago of Senator the Honorable Satyakama Maharaj, given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President, St. Anne's, on this 14th day of November 2025. By Her Excellency Christine Carla Kangulo, ORTT, President of the Republic of Trinidad and Tobago, and Commander-in-Chief of the Armed Forces. To Dr. Kirk Megu, whereas Senator the Honorable Dominic Smith is incapable of performing his duties as a senator by reason of his absence from Trinidad and Tobago. Now, therefore, I, Christine Carla Kanglu, President as aforesaid, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(a) of the Constitution of the Republic of Trinidad and Tobago, acting in accordance with the advice of the Prime Minister, do hereby appoint you, Kirk Megu, to be a member of the Senate temporarily with effect from the 14th November 2025 and continuing during the absence from Trinidad and Tobago of Senator the Honorable Dominic Smith, given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President, St. Anne's, this 14th day of November 2025. Honorable Senators, 2 senators are required to take the oath. Can we all stand?
Excuse me, that's all right.
I, Ashwa Jack, having been appointed a member of Parliament, do solemnly affirm that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, will conscientiously, impartially discharge the responsibility of the people of Trinidad and Tobago upon which I am about to enter.
Testing, 1, 2, 3, testing.
I, Dr. Kirk Megu, having been appointed a Member of Parliament, do swear by the Bhagavad Gita that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
questions or notice questions for oral answer.
Mr. President, I'm very happy to announce that the government is pleased and ready to answer all of the questions appearing on the order paper today, to wit, questions numbers 10, 12, 13, 14, 24, 25, 27, 28, and 29. And I still hope that we can have an early date today.
Senator Melanie Roberts Rajman.
Question number 10 to the Minister of Homeland Security.
The Honorable Minister of Homeland Security.
Good morning, Mr. President, and thanks for having me in this honorable house to answer these questions. Based on the information received from the Commissioner of Police, the Trinidad and Tobago Police Service, under the oversight of the Ministry of Homeland Security, has activated a multi-tiered approach framework to ensure accountability, investigative integrity, surveillance, compliance, and comprehensive review of police actions. In this regard, the following measures are currently in effect. Independent investigations and oversight by the Police Complaints Authority, clear use of the use of force policy, discipline consequences, data reporting and statistics, public communication and transparency, instructions given to investigators with timeline to comply. Investigations include immediate scene management, independent oversight, separation of the officers involved, timely and transparent reporting, use of forensic technical tools, communication with the public, and training of investigators. Mr. President, parallel administrative and criminal procedures. Administrative review, whether the officers followed TTPS policy. Criminal investigations, whether shooting breached the law, whether the shooting breached the law, and running them in parallel, presence, delay, and ensuring firmness. Surveillance, Mr. President. Use of distributions of body-worn cameras. Policy, departmental order, mandate use. Oversight, again, by the Police Complaints Authority. Standard for evidence, data, and privacy. Public parliamentary oversight and reporting. And finally, Mr. President, the review of police actions. Investigations by the PCA, use of force policies and legal frameworks, policy mandate to wear body-worn cameras, National Security Council and regulatory revisit or review, and public transparency and reporting. That answers the question, Mr. President.
Thank you, Mr. President. Through you, I have 3 supplementals, please. The first supplemental to the minister, you indicated that information on the status of investigations are being communicated to the public. Can the minister indicate what method is being used, and how are these investigations being reported? Thank you.
The Honorable Minister of Homeland Security.
Mr. President, as it relates to the giving information to members of the public, the police service through its information technology department issues information to members of the public via its website.
Senator Rajma.
Mr. President, my second supplemental, the minister indicated that there are timelines for completion and submission of reports. May I please ask the minister how these timelines are being enforced and how are investigative officers being supported to ensure that these timelines are actually being met?
Mr. President.
The Honorable Homeland Security Minister. Yeah.
Mr. President, the timeline is an instruction given by the senior police officer to the investigators of any offense that is committed. A time frame is given, and if additional time is required, it is then applied for.
Senator.
President, the minister also indicated that there is a body cam policy and a use of force policy that's being enforced presently. Can the minister indicate whether these policies are new, and also if he can submit a copy of these policies for review? Thank you.
The Honorable Minister of Homeland Security.
Mr. President, these policies are not new. The use of force policy has been engaging the attention of law enforcement, if I recall, since 2007 or 8. And also, the body-worn cameras, also, this policy is not new. Thank you. And to answer the question, you asked another question relating to the copy. I will try to have it brought to this honorable house as soon as possible.
Can you guys hear me?
Senator Faris Alwari.
To the Honourable Minister of Homeland Security, question 12.
The Honourable Minister of Homeland Security.
Mr. President, with respect to the question, based on information received from the Commissioner of Police, the following information is relevant. As of September 2025, virtual hearings are actually conducted at 13 police stations around Trinidad and Tobago. And virtual hearings conducted at these designated police stations accommodate the full spectrum of criminal matters, ranging from summary offenses such as simple assaults and public order breaches to indictable offenses, including serious crime such as murders. And 3, with respect to the data required, a comprehensive cross-reference exercise between the virtual courts and the attendance at to maintain the judiciary and the station level lodged. Mr. President, we haven't yet got that information with respect to the amount of persons who would have attended these hearings over the time frame. Also, with respect to the data concerning the domestic violence matter, hearing in virtual courts. Mr. President, The identification of police stations between 2000 and 2025 is not immediately available. Accurate reporting requires a coordinated review of the judicial case file alongside TTPS station level recording to ensure completeness and consistency. Given the value and sensitivity of such matters, the information is not readily available. A detailed and verified response will be provided in due course. Once necessary tabulations and cross-checks have been completed.
Yeah, Senator Faris Alwari.
Thank you, Mr. President. Thank the Honourable Minister for the answers. Supplemental question number 1. In relation to the answer provided by the Honourable Minister as to item 2 of the question, I ask, what is the total number of police stations versus the 13 now given in answer where virtual hearings are conducted as designated centres?
The Honourable Minister of Homeland Security.
Mr. President, the 13 I mentioned are in fact used as virtual court up to this date.
The Honourable Senator Faris Alwari.
Regrettably, the Honourable Minister hasn't answered the question. I'm asking for 13 out of how many, if I put it quite simply.
Okay. Mr. President, 13 out of 77.
Thank you.
Okay.
Thank you, Honourable Minister. Thank you, Mr. President. With respect to the answer provided to item 3, could the Honourable Minister indicate when the response to this exercise of audit, if I put it that way, will be completed, bearing in mind that 7 months have passed since the answering of this question, since this question was posed? So insofar as 7 months has passed,
No.
could you answer?
Just ask the question.
I did.
Please. The Honourable Minister of Homeland Security.
Mr. President, for the accuracy of this information, we depend on the organizations to present it. So we want accuracy before we bring it before this Honourable House.
Senator Faris Alwari.
Mr. President, with respect to the answer provided to part 4 of the question, I ask, when will this data be provided insofar as 7 months have passed? And just for clarification, the Honourable Minister mentioned a period of 2000 to 2025. The question was 2020 to 2025.
The Honourable Minister of Homeland Security.
Yeah. Can I, Mr. President, put the answer to the Honourable Senator in writing?
You okay? Okay. Senator Faris Alwari.
Mr. President, to the Honourable Minister of Homeland Security, question 13.
The Honourable Minister of Homeland Security.
Mr. President, as it relates to the police stations, as I will repeat, 77 police stations in Trinidad and Tobago are presently occupied by police officers. The locations of the police stations being used as virtual courts: Arima, Besson Street, Chagonas, Couva, Liaro, Point Fortin, Princess Town, Rio Claro, San Fernando, Sandy Grande, Scarborough Tobago, Siparia, and Tunapuna.
Yes. Yes. Okay. Senator Faris Alwari.
Question 14 to the Honourable Minister of Homeland Security.
The Honourable Minister of Homeland Security.
Mr. President, relative to the question by the Honourable Senator, a comprehensive review is being undertaken relative to the parties with respect to the situation that exists with the virtual hearing in order to come to a compromise as to how we go forward.
Thank the Honourable Minister for the response. In light of the response, I asked the Minister, on what basis then did the Minister speak, as reported in the newspapers, that there was a certain policy to cancel virtual hearings at police stations?
I think...
the Honourable Minister of Homeland Security.
Mr. President, I think that the Honourable Senator misunderstood what I said. As usual. Give me the opportunity to correct the goodly senator and the reporter, as usual. Mr. President, what I said was that the courts was occupying areas of the police station, and as a result of that, the police, different units, would have lost their ability to continue investigations, to do identification parade, and it can go on and on. That is what this statement was about. Thank you.
With respect to the answer given to the supplemental question, is the Honourable Minister therefore stating that he was misquoted by the media?
I would have already addressed this from my last conversation, Mr. President. Thank you.
Any further questions?
Yes, please.
Yes.
Thank you for the supplemental answer. In light of the supplemental answer, is the Honourable Minister therefore willing to retract the statement that I have misquoted you insofar as my question was posed on the publications in the public domain by the media?
Mr. President, under Order 27.9, that does not arise in relation to the last answer.
Okay, sustain. Any further supplemental? Okay, right, thank you. Let's continue. I invite Senator Melanie Roberts Rajman at this time.
Thank you, Mr. President. Question number 24 to the Attorney General, please.
The Honourable Attorney General.
Mr. President, the question is broken down into three parts. Parts 1 and 2 are, in my respectful view, tautologous. Now, the answer, nevertheless, is as follows. The process leading to the settlement of the legislative agenda has lasted several months. The agenda is in its final stages of development. It is anticipated that the agenda will be read in the House of Representatives within the next 3 weeks.
Senator Melanie Roberts-Rajman.
Thank you again, Mr. President. Question number 25 to the Minister of Defense.
The Honorable Minister of Defense.
Mr. President, I'm instructed that 14 drownings occurred during the period identified in the question, 5 of them at Mearo, 6 at Toho. All of them occurred outside of the patrol hours and outside of the patrol areas. There was 1 in Los Iro, which occurred beyond the patrol area, and 2 in Maracas. We have not had such a spike either before or since the period identified in the question, and there's therefore, I am instructed, no need for any change to the existing signage and arrangements.
Okay. Senator Melanie Roberts-Rajman.
Thank you again, Mr. President. Question number 27 to the Minister of Homeland Security.
Question, the Minister of Homeland Security.
Mr. President, relative to information received from the Commissioner of Police, the total number of criminal offenses reported across all divisions are as follows: 928 for May 2025, 919 for June 2025, 1,056 for July 2025, 842 for August 2025, and 749 for September 2025. The second part of the question, Mr. President, the total number of criminal offenses detected across the divisions are as follows. For May 2025, 257. For June 2025, 315. For July 2025, 355. And August 2025, 305. And as of September 2025, 272.
President, there are 2 other bits to the question, 2 other parts.
You have 2 other parts.
All right. As it relates to part 3 of the question,
Right.
in relation to the publication of statistics referred, the Trinidad and Tobago Police Service, through its Information Technology Department, is currently reviewing the process of publishing the data on its official website. Once the verification and approval is granted, the process is completed, the information will be made available, publicly available, on the TTPS website.
Outlined in Section 5 of the Bail Act, so that we say that they will have no authority to grant bail, where Parliament has expressly placed a higher threshold on the accused. And before my colleagues opposite jump on me for this, if you look at the decision of Justice Gobin in the case, what she says is this. She says the power of justices of the peace to grant station bail to persons charged with indictable offenses, and then there are some important words. What she says is, subject to any statutory limitation, is restored with immediate effect. So, I mean, it's obvious to me that she was making an exception to contemplate precisely what we've done. And if you go down to paragraph 63 of the judgment itself, she says, it is not in every indictable case that a JP would be entitled to grant bail. Mr. President, I therefore commend the bill and the amendments to this honorable House, and with those few words, I'd like to
Honorable Senators, I shall now propose the question for debate. The question is that a bill entitled An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011, be now read a second time. The Honorable Faris Al-Wak, Senator Faris.
Thank you, Mr. President. I thank the Honorable Attorney General for piloting this debate. Permit me, in the scarcity of 45 minutes, to be as direct as I can. We received the bill as amended in the House of Representatives and began preparations, and it turns out that yesterday very important amendments were circulated to the House, to the Senate. Those amendments, unfortunately, I confess, came to my attention at 8 o'clock this morning. I think they are very important amendments and are very worthy of consideration, but I wish at the outset to state that those amendments are very far-reaching in terms of the original bill and that which involves the amendments as we're now debating together with this. I do thank the Attorney General for circulating those amendments. That was very considerate of the Senate's time. We're dealing with two issues effectively in this bill, as amended and as proposed to be amended at committee stage. The first is the issuance of search warrants. The second is the issuance of bail. If I state plainly the position that I asked to be considered this morning, it is that the opposition has taken the view that the amendments as it relates to the inclusion of justices of the peace with respect to search warrants ought not to prevail today for the reasons which I propose to go into shortly. However, there is no objection, at least from my point of view, waiting on this debate to unfold, in relation to the issue of bail and justices of the peace being statutorily clothed with their common law rights and obligations and privileges as reflected upon by Justice Gobin in the case of Joel Alexander and the Attorney General. With those two mischiefs from a legislative point of view tabled, permit me perhaps to address the latter issue first, which is that of bail. Now, in the case of Joel Alexander and the Attorney General, which has been concluded, I take it from the contribution of the Honourable Attorney General that there will be no appeal to this case, so therefore we're not traversing any sub judice rule. I think that the Honourable Attorney General is correct in surmising that there ought not to be an appeal to this case, and therefore this case, even at the High Court, stands paramount. It's quite interesting that the judge in this case, Justice Gobin, is perhaps the go-to person on bail in the first place. She's made quite a few pronouncements in relation to bail. I, too, like the Honorable Attorney General, harbored serious concerns as to the constitutionality of the automatic exclusion of bail for murder and for other offences, as came forward from the 1996 Bail Act and continued into force. For the same reasons, whilst I was in the Senate in the period 2010 to 2015, I cautioned then Attorney General Ram Logan as to the need for sunset clause to prevail, because I always felt, firstly, that the law wasn't necessarily saved law. Secondly, that any attack against the fact that it was not saved law would be trumped, would succeed on the basis that bail as a common law right had existed for quite some time, and therefore you were skirting interpretation from saved law within the meaning of Section 6 of the Constitution. Achille Charles came along. Indeed, I was Attorney General at the time when that case came and went to the Privy Council, and I felt that it was bound to be a conclusion by the Privy Council that Section 5(1) of the Bail Act would fall, that you could not deny the right to bail. But nonetheless, we were carrying amendments passed, as the Honourable Attorney General said, since kidnapping for ransom had reared its head in a sustained way, but even prior to that, since the 1996 codification of no bail for murder, etc., had happened. With that said, the Achille Charles case, the Privy Council authority says that the common law prevails in respect of the grant to bail. The reversal of the burden in consideration of bail was something that I introduced as Attorney General, specifically as an amendment to Section 6 by the inclusion of a new Section 7A, which said that the defendant would show cause as to why he should get bail. We borrowed that from Canadian jurisprudence and jurisprudence elsewhere to provide constitutionality, which we believe holds proper muster. That was repeated in the 2024 bail amendments and came to take root. The 2024 bail amendments came about because when the bail legislation could not be continued in terms of a sunset clause being denied, we had to go back to the entire law as it stood at 1996 plus one amendment. The consideration of Madam Justice Gobin in relation to bail in the Joel Alexander case is, I agree with the Honourable Attorney General, very important. I wholeheartedly support the conclusions of the court, but I want to remind that the conclusions of the court really was not that the law itself was ultra vires. The judge at page 29 ruled that there was a declaration that Section 10 of AJIPA did not have the effect of removing jurisdiction of justices of the peace to grant station bail to persons against whom charges were laid indictably. Secondly, the judge ruled that the policy which removed the power of justices of the peace to grant bail in such circumstances is declared to be null, void, and illegal. The judge held that the power of justices of the peace to grant station bail to persons charged with indictable offences is restored, subject to statutory limitations with immediate effect. The judge, in making those declarations and so holding, was effectively setting aside the way in which the law was operationalized, both by the Trinidad and Tobago Police Service and by way of policy prescriptions that revolve around it. And that is squarely met by the fact that it had not been tested. Now, I can say now that as Attorney General then, I developed the policy in relation to the amendments that came in 2023. That's Act number 12 of 2023. And there were umpteen stakeholder contributions which occurred then. So for the record, Mr. President, AJIPA was born in 2011. We had serious problems with when it was brought into effect, including the premature operationalization of Section 34. It was amended in 2012, 2019, 2019, 2019, 2020, 2020, 2020, 2023, 2024, 2024. 10 times, not 9. I was a participant in every single one of those amendments. And in relation to those amendments, Mr. President, I can say that there was very deep consultation. And that deep consultation actually is part of the records of the Attorney General, no doubt. But from my recollection, it included, at the very least, 24 consultations with key stakeholders. In everyone from the Ministry of National Security, the Trinidad and Tobago Police Service, the Judiciary, the Office of the Director of Public Prosecutions, Senior Counsel, the Public Defenders Division, Commissioner of Police of St. Lucia, Director of Prosecutions St. Lucia, we went extraterritorially. And under the convened Justice Committee sector group, which the Honorable Chief Justice chaired, we sat and we went through clause by clause, section by section, the AJIPA legislation. Nowhere in those reflections was there ever an intention of amending the Summary Courts Act and the Summary Offences Act such as to deny bail by a justice of the peace. Nowhere. Instead, the bail was preserved specifically, as the Honourable Madam Justice Gobin held and reflected upon in her ultimate determinations, because the Honourable Judge correctly pointed to what was contemplated in those consultations, that bail would continue in respect of summary offences, that justices of the peace would have concurrent jurisdiction with magistrates, etc. Now, what the judge very usefully did in the Alexander case was to separate a very important point. The judge said, look, the constitutional right to freedom in Section 4 of our Constitution, the enshrined right, has to be borne in mind when you look to the practice of justices of the peace. In that station bail at the moment at which you are arrested is still a very important factor. And the judge went through the Alexander circumstances of being charged for obscene language and resisting arrest, and ultimately spending several days in prison because he couldn't access a master because of long weekend or other factors. And what the judge held is that on the basis of the law as it relates to implied repeal, on the practice as it existed, on the common law factor, on the law of construction, being excluded from Pepper and Hart, meaning you couldn't go to the Hansard to look for it, but you could construe the law other ways. The judge said, look, the policy that was adopted by the police and by the judiciary of insisting that indictable offences, any bail applications with respect to charges for indictable offences, had to go to the master, and excluded by that practice the access to a justice of the peace for 24/7 access to bail, as the judge put it. The judge held that that surely could not have been the intention of the Parliament, because the judge correctly referred to A, the position of implied repeal, B, that it must be express if you're dealing with that, C, that the Parliament had the power to treat with creatures of statute, meaning masters, registrars and clerks of the court. In all of those creatures of statute, the Parliament could deal with its position, but the judge felt and held, and I think correctly so, that justices of the peace had to be put into a different position, ultimately because we're talking about the fundamental right to freedom. Now, what was interesting as well is that the judge also reflected upon doubtful penalization, and really said that you couldn't move to penalize something if it wasn't expressed. So the simple position is this. The judge said, if there wasn't an express ouster of justices of the peace with respect to bail, the judge held that the policy which ousted justices of the peace was wrong, because the law itself, all of the amendments to AJIPA, and particularly Act number 12 of 2023, did not expressly remove a justice of the peace for the purposes of bail. Now, in reading the judgment of Madam Justice Gobin and Joel Alexander, I see that evidence was submitted on behalf of the Office of the Attorney General. I have not seen that evidence, but it seems that that office went on to speak to what the policy was. I want to say now, in relation to marrying the two issues of bail and now search warrants, the specific policy that was adopted through umpteen consultations over a number of years was with respect to the removal of the power of magistrates and magistracy registrars and clerks of the court and justices of the peace with respect to search warrants. And why was that the case, Mr. President? That was the case because the issuance of search warrants also affects another very important right. And again, we go to Section 4 of the Constitution, Enshrined Rights, and we're looking at the right of an individual to life, liberty, security of the person, enjoyment of property, and the right not to be deprived thereof except by process of law. We're also looking to the right of an individual to respect for his private and family life. And when we look to those two particular enshrined rights, and we borrow the way in which Madam Justice Gobin looked at the fundamental right in relation to bail and held as she did, and I think correctly, we must now enter into an exercise of considering the aspect of search warrants being issued, in our case, in the opposition's position, by justices of the peace. We consider, based upon the policy followed for over 10 years of participation, that matter, and I note the Honourable Attorney General indicated to us that he had an urgent matter to attend to, so that we're to take no offence by his temporary departure, and I accept that. But we note, in relation to the 10 years of policy, that there was a deliberate consultation and perspective on, in particular, persons other than a judge or a master issuing search warrants. Why? That's to be found in the AJIPA Act itself. And that's to be found in Section 5 of that Act. You see, Section 5 is where a master is satisfied on proof of certain factors. The master may issue a warrant for a search. The search warrant may authorize one or more sets of premises specified to be searched, any premises controlled or occupied specified in the warrant if the master is satisfied that you can't ascertain what the premises actually are. In other words, then you have a roving search warrant provision, a very wide position. Now, the Honourable Attorney General challenged the Parliament to say whether there's any mischief in relation to justices of the peace, and I can say so, yes. One needs only reflect upon the dicta of the court in the Brent Thomas matter, where the Honourable Judge, in deciding that case, said no justice of the peace effectively should have issued those search warrants, and he referred the matter to the Justices of the Peace Association. The key for discussion here today is, are we satisfied that allowing the Justices of the Peace the power to issue search warrants, which are roving, which are wide, and which are continuing, because we fundamentally changed the law with respect to search warrants in the last 10 years, is that acceptable in the context of the fundamental right for deprivation of property, etc.? In fact, we heard the Honourable Attorney General refer to a case that I haven't heard for a very, very long time, and that's the case of NTIC. In fact, I will say no. The first time I heard that case was from the lips of the Attorney General when he was my lecturer at law school. It's a long-standing case. It is the 18th century jurisprudence that no man should allow anybody to enter his clothes without permission. So here we have the search warrant positions, and the policy which the government, judiciary, DPP, law association, public defenders, other governments in the Caribbean, the 28 people consulted, the policy which you came up with was, because justices of the peace are not clothed with judicial authority, in this instance with respect to search warrants, and by that let me qualify it, I don't mean judicial authority in the sense of a failure to acknowledge it in the Summary Courts Act or elsewhere where they have the power to act as justices along with magistrates, but insofar as they are not protected by mechanisms such as determined in Hines, that is by a Judicial and Legal Services Commission, or with specified conditions for qualifications, or for discipline, or for record keeping, the state and condition of justices of the peace in this jurisdiction, in light of the very draconian power that we created as a parliament under Section 5 for roving and wide search warrants, the policy decision was to exclude justices of the peace on purpose. We also included the removal of magistrates, magistracy registrars, and clerks of the courts because there was an attempt to streamline indictable offences to the High Court. Now, it wasn't that that was going on in a vacuum, because I can tell you, Mr. President, I listened to the debate in the House and I heard a most untruthful submission from the Minister of Legal Affairs, the Honourable Saddam Hussein, saying that nothing was done in relation to justices of the peace. They just left it like that. Ridiculous. I personally sat, after instructing the Law Reform Commission, to develop the Justices of the Peace Bill 2023. It's there in the Office of the Attorney General, now transferred to the Minister of Legal Affairs. He should have known very well, clearly didn't do his homework. The Bill for Justices of the Peace 2023 is a profound piece of legislation. And the intention was that we would upskill justices of the peace. We would, in a bill containing 12 parts and 60 clauses and 7 schedules, that we would insist that justices of the peace have legal qualifications, or if they were existing justices of the peace, that they had a certain tenure in office. We would subject the approval and functions to act as justices of the peace to a Justices of the Peace Advisory Board. That advisory board would scrub the Justices of the Peace's qualifications and standing. That advisory board would report to the minister. The minister would then consider. So this was something very different from the creation of Justices of the Peace under the summary courts legislation. Because Justices of the Peace at present are simply appointed by the President. It is not with discretion. That means Section 80 of the Constitution applies. That means the Cabinet effectively effects the decision. And the Cabinet can, in all circumstances, delegate authority, and in fact, the authority was delegated to the Attorney General. So right now, Justices of the Peace, and I make no aspersion against the Honourable Attorney General, he, like every other Attorney General, has the power to appoint Justices of the Peace. But we were moving away from a position of no qualifications, no protection by the Hines backing, meaning a judicial and legal services type of independence. In this Justices of the Peace Bill, we were moving to disciplinary action, reporting requirements. The Justices of the Peace had to file anti-money laundering, counter-terrorism financing, countering proliferation financing forms, which were kept private. There was a full register for public examination. They had 3 years of qualification and licensing, after which they must have a reapplication process. It was a profound series of amendments because the intention was always to reintroduce Justices of the Peace once they were clothed with protection, which gave protection to the fundamental right in Section 4 of the Constitution of the right to property. Now, Justice Gobin, in her decision, was reflecting upon the words of Mr. Justice Barrow in the case of civil appeal Rihanna Lorick and Joanne Pantin versus the Attorney General. And the words that she quoted at page 1 of her judgment, the constitutional rights conferred by Section 4 and 5, and in particular, in this case, the right to liberty, are hard-won rights. The judge was saying about the paramountcy of Section 4 of the constitutional entrenched rights. This can easily be applied to the right to property. It follows with the Entick case, the 18th century case, that you should not allow somebody into your clothes, meaning your property, without proper authorization. But when we look to the massive expansion of the power of search warrants, we, by dedicated decision after deep consultation, took it to the point where we excluded, in particular, Justices of the Peace. The case of Brent Thomas proves that justices of the peace can issue warrants. Now, let's reflect upon a law that has just come into passage. The FATF Compliance Bill amendments gave the power for undercover operations to the Trinidad and Tobago Police Service under the Mutual Assistance in Criminal Matters Act, under the Anti-Terrorism Act, under the Financial Intelligence Unit Act. Full civil and criminal immunity, blanket, no conditions. I circulated, with your permission, the control operations law that we drafted, that I set into draft, which showed why it should have conditionalities and the use of a warrant to go undercover with cautions and supervision by the court. It was not accepted. The Honorable Attorney General gave an undertaking at the time that he would look at it, that there was merit in it. But today, are we going to give search warrants to a justice of the peace, having watched what happened in Brent Thomas, under a state of emergency, moving and complete position, ultimately to give full civil and criminal immunity from prosecution to police officers and other officers under the 4 laws I've quoted: Trinidad and Tobago Police Service, Mutual Assistance in Criminal Matters Act, Anti-Terrorism Act, Financial Intelligence Unit Act. We are on this slippery slope where the best intentions may cause problems. And therefore, I have a heartfelt reservation against expanding the powers of justices of the peace being included in the category of persons who can issue search warrants. If there was an amendment simply to remove justices of the peace from search warrants, we would have no problems. Why? In every single bill, in my tenure, I passed over 600 laws as Attorney General. In every debate that I came to the Parliament on, I brought data, figures, statistics, particulars of consultation. I put it on the record. Why? Because I was very concerned to ground the proportionality justification in case of a challenge. I want to remind you, Honourable President, that whilst the government last in position was there, and whilst I was Attorney General, there was a constant refrain of proposed attack on the use of the case of Surat, that is proportionality. There was a threat every single debate: we'll overturn it, we go into court, you and Surat, you had to get a 3/5 majority, this is unconstitutional, until we went to the Privy Council in the case of Suraj, and the Privy Council upheld the entire legislative agenda which I led and which the PNM prosecuted, to go by proportionality as justifying the reasonableness of legislation. In the failure to produce statistics here today, we have no genuine reflection on what the statistics show us. We are to just accept. I read the debate of the Honourable Attorney General in the House carefully. He anchored his position in the fact that there was a need for search warrants in this state of emergency. That caused great alarm for me. We have treated summary offences and indictable offences almost indiscriminately. There's some very heavy penalties for summary offences and terms of imprisonment. Sort of akin, if you look to the Copyright Act, you look to other positions, you see $1 million and $2 million summary offences. We have to be careful to distinguish the line between indictable offences and summary offences, but an indictable offence is nonetheless regarded in law as a more serious category of offence than a summary offence. And in respect of the indictable offences, interception of communication being one of them, search warrants in general being one of them, anti-terrorism, anti-gang, it's very wide. Mr. President, we would be effecting an irresponsibility to revert to the inclusion of justices of the peace. I can accept, philosophically, the inclusion of magistrates and magistracy registrars and clerks of the court. Why? When I was Attorney General, we took the deliberate step to eliminate justices of the clerks of the court who were unqualified, had no legal backing, Effectively, they were breaching the Legal Perfection Act by engaging in law when they couldn't. We eliminated that and we created magistracy registrars and clerks of the court so that they would have legal qualifications and supervisions, etc. So that it's an entirely different class from the justices of the peace. You need only to go to the Summary Courts Act, Chapter 420. You'll see the qualifications for a master. You'll see the qualifications for magistrates. For magistrates, you see it in 420. For a master, you see it in the Supreme Court of Judicature Act. They are clothed, they are supervised, they are accountable. The justice of the peace in Trinidad and Tobago, without a law such as the Justices of the Peace Bill 2023, is dangerous in the context of indictable offenses. Because when you look to the breadth of search warrants under Section 5 of AJIPA, multiple premises, even if you can't name them, if they're owned by somebody and you find out that they're owned by somebody, yeah, we have a search warrant for X, we found out X has a property that is owned, we go in there. By a justice of the peace, when you read Brent Thomas, what is the Justice of the Peace Association going to do to discipline that Justice of the Peace that granted it? Mr. President, without being pejorative in any expression to Justices of the Peace, I've seen drunk Justices of the Peace issue warrants.
Mic check, mic check.
I'm entitled to speak to my own experience. What can you all tell me?
Testing, testing,
this is
testing.
something that I know for a fact.
Testing, testing.
Dangerous. The
Mic
key
check,
is,
mic
Mr.
check,
President,
mic check. Why
we
is
have
this
to,
shit
today
working?
we're discussing a very important bill as proposed to be amended. It's apparently very short.
Oh,
it
finally
looks
came up.
very innocuous. It appears to be a debate on just resource constraint. It is not that. There are divisible avenues in this bill. The clarification of the law by statute to statutorily codify the interpretation of Madam Justice Govin in the Alexander case, 100% correct. Now is the appropriate time to do that. It doesn't matter that it came late to us. The fact is that the judgment just came. The Honorable Attorney General is not going to seek to appeal it. We have an opportunity now. Agreed. The issue of search warrants. How much time do I have, sir? Thanks. The issue of search warrants is a different category. I genuinely believe that the Justices of the Peace Bill, as drafted, it's an excellent bill that is in the Office of the Attorney General.
Faris is putting me to
Thank
sleep.
you so much, sir. It is in the Office of the Attorney General. It should be in the hands of the Minister of Legal Affairs, the Honorable Saddam Hussein. It appears that it's not, because he went on a tirade which was untruthful in light of the fact of its existence. But we need to clothe Justices of the Peace quickly. And Mr. President, I don't think I need to belabor the point. Our simple...
How is the audio coming through? Because I'm messing with the audio
There are two
while we're live.
in this bill.
Is my audio clear? Am I coming out clear?
The second of which, Clark, Julian, the second of which is the...
So this debate is about search warrants and bail. Apparently the UNC is trying to empower justices of the peace to give warrants, and he's going against it.
The judge never held that Section 10 of AJIPA was unconstitutional. The judge didn't reflect on the policy of the law. The judge simply said that the practice used by the police and the judiciary was wrong, and the Justices of the Peace should be allowed to continue with their common law duties. The first mischief is the inclusion of a wider category of persons to authorize search warrants under the Administration of Justice Preliminary Inquiries Act. That could only be in Section 5 of that Act and any other laws that permit it. And in that regard, the inclusion of Justices of the Peace is objectionable because of the evidence that you have in matters such as the Brent Thomas case and many more matters. Our recommendation, Mr. President, is that we simply remove the reference to Justices of the Peace with respect to the grant of search warrants, and the opposition would be very happy to support those proposals. Mr. President, I look forward to observations coming from the Senate as a whole, and I thank you for this opportunity.
Senator Sophia Chote, SC.
Thank you, Mr. President, for the opportunity to contribute to this debate. We are being asked today to look at a proposed amendment
Testing,
to
1, 2, 3,
Section
testing.
10 of AJIPA. I'm sorry,
Test,
I don't
test,
know why
test.
I'm
Why
getting
is this
feedback.
microphone
Maybe that
active?
I'm standing too close to the microphone. Section 10 of AJIPA, which basically says that the powers which a master now has in relation to the issuance of a search warrant should be broadened to allow certain other office holders to grant search warrants when applications are made to them. So what the proposed amendment is saying is, let's allow magistrates to grant search warrants. Let's allow magistracy registrars to grant search warrants. Let's allow court clerks to grant search warrants, and let's allow justices of the peace to grant search warrants. Now, I must confess that I learned a lot by reading the account of the debate in the lower house, and in particular, the contribution of the Minister of Land and Legal Affairs, because I think what the Honorable Minister very candidly, and I think he should be commended by us, by all of us, for his contribution, what he very candidly set out to this country was the state of affairs in which the justices of the peace had found themselves after all of these years. And he very candidly, and I would say that took a lot of courage from a minister of government, because he explained that, listen, we are here asking for this legislation, but I'm not hiding from you the fact that this is the state of affairs with respect to justices of the peace. He brought to our attention, for example, that justices of the peace were not even properly listed. And under his ministry, I see that in May of 2025, he had gazetted a list of what the ministry had as justices of the peace. But, Mr. President, I have been around for so long now, even I, looking at that list, can say that list which the ministry has is incomplete, because I identified at least one, possibly two people deceased who are still listed on the list that the ministry has. And I'll tell you why I think that's a dangerous thing. It's because, you see, there is no responsibility on the part of the Justice of the Peace or the Justice of the Peace Association to advise the ministry. Let us say a Justice of the Peace has become incapacitated, he has mental health issues, or he's got a stroke and he is in hospital and he can't discharge his duties and that kind of thing. There is no one with the responsibility to advise the ministry of this state of affairs. And in fact, no one responsible to even advise the ministry.
So I'm using this gold microphone in front of me. This is the one that was staticky in the past.
While with the best interest of the country,
Trying to learn this interface.
the Honorable Minister sought to tell us, well, look, you may not have known before, but I'm telling you now in May 2025 that this is the list we have of justices of the peace. Even his list was inaccurate. When I looked at the gazetted list, I also made a very startling observation, which is to say, there is someone on that list with a case pending before the court, charged with a very serious matter. So how are we going to deal with the population of the list and the fact that we are giving broad powers to justices of the peace?
Welcome, Fearless. Welcome, Sadiqa.
Without
Welcome, Daniela.
knowing the background information or having a system in place so that the ministry under which they fall will be up to date and will know how to act.
Did I
Now,
say that name correctly,
again,
Sadika?
unfortunately, because I've been around for so long, I have come across instances where there was a justice of the peace who fell ill in a certain district. And while the poor man was there, ill, not knowing what was going on around him, it appears as though some clever police officers
Did I pronounce your name correctly?
took upon themselves to, it appears, I say, to take his stamp, and search warrants were issued with that justice of the peace's stamp and a signature. So it means that unless we have a system up front which is accountable, I cannot in all conscience, and pursuant to the prayer which was said at the start of our prayer this morning, conscience support justices of the peace having the power which a JIPA gives them. Because Senator Al-Rawi, my friend Senator Al-Rawi, was very correct when he made the observation.
Renison is supposed to come on with a presentation at 12 o'clock, so when it comes closer to 12, if this is still ongoing, I'll have to come off for that. Or maybe we can test a dual stream, dual lives at the same time. Maybe we might do that if Renison goes live at 12.
Suppose the saving grace there is Section 5 was saying, okay, we are giving a judicial officer the power to authorize searches, but we are only giving that power to certain people because they have the training, first of all, so they will know what they are supposed to be considering, but also because they are accountable. If they act improperly, they can face disciplinary action. What disciplinary action does a justice of the peace face when acting improperly? We have a plethora of cases which have gone through the courts. And again, what usually happens when a police officer goes to a justice of the peace?
So once again, this debate right here is about the UNC is trying to empower justices of the peace, justice of the peaces or justices of the peace to issue wide-ranging search warrants. And this is the debate against
So
it.
the police officer goes and he says, I'm acting on instruction. So he fills out a form which is called a complaint. He goes to a justice of the peace. The justice of the peace takes the form, reads it, more often than not doesn't ask a single question. The police officer raises his hand, he takes an oath, and there you have the power given to the police.
I'm doing great,
to
Sidika.
carry out searches under the
Now that my
very
audio is dialed in,
power
it took me like 45 minutes talking before the audio finally came up.
frightening contemplation or possibility for the citizens of this nation as a whole. Mr. Thomas, as horrible as his circumstances were, at the end of the day, had the benefit of a lawyer, had the ability to engage a court, had an attorney general who was fearless enough to say that we are not going to contest his application. What does your average citizen have when confronted with a search warrant obtained in these circumstances? I think common sense will give us the answer to that. Now, I want to go back a little bit to why I called a JIPA draconian. Because a JIPA said, listen,
A JIPA is case law that she's referring to. So they're referring to past cases that debated that had a debate about these justices of the peace and the search warrants. So they're just like doing a legal debate on the case law.
that you want to search 2 or 3 other people's homes or businesses, you now have that power. So the search warrant is not confined to the premises. it may go on to other premises, which would include homes, businesses, and so on. The search warrant can permit multiple searches. There is no time limit set out in the Act as to how long that period of search must be. It simply says multiple searches, and the master has the power to say, well, you can carry out your searches within a 2-week period, a 3-week period, whatever it is. But you see, these nuances are important because it assumes, I think AJIPA assumes, that the person giving consideration to the application for the search warrant will take issues like reasonableness into account, may ask questions of the officer applying for the search warrant, may say, look, listen, I am not satisfied, come back with some additional information for me. Is that what happens before a justice of the peace? The answer is no.
That's right.
Our lived experience.
So why is the UNC trying to empower justices of the peace to issue search warrants? What is the reason behind that? Why is the UNC insisting on making policies that lock up people?
1997, when the Honorable Attorney General at that time was Mr. Ramesh Lawrence Maharaj, Senior Counsel. Mr. Maharaj recognized that what justices of the peace were doing was that they were hanging around the prisons and approaching the relatives and friends of incarcerated persons so that they could offer their services to grant bail. They were touting to grant bail outside of the prisons. So what the Attorney General at that time did is he said, listen, let my ministry, and he did in fact do it. It is such a pity that it did not become legislation in any form. So what we have now is a good guideline, but it's just moral suasion. He created a handbook for justices of the peace. So he said, look, if you're dealing with confessions, justice of the peace, as part of your duties, follow this. You're dealing with ID parades, follow this. You're dealing with search warrants, follow this. But very importantly, in that document, and I think it is such an old document, it can't be found digitally. At about page 62 to 63, he set out a code of ethics. I'm very disappointed to say, and again, I can speak from lived experience, that because so much time has passed, not even attorneys know that this handbook.
This is an interesting story, actually. I'm enjoying this.
Appointees as justices of the peace don't know. I myself have asked questions in court, in trials of justices of the peace. Have you seen the handbook of justice for justices of the peace? They have heard of it, Mr. President. So not even justices of the peace have an idea of what we as a country, and today what we as a Senate require of them. So in no sense of the word, when you look at the word accountable, in no sense of that word or the understanding of that word, can you get the impression that this is a person holding a public office with the capacity to know what is required of him or her under AJIPA, with the ability to comply with AJIPA's demands, to understand that he or she must have systems in place to reflect that accountability. Because this takes me to another point. I understand that the problem is that police officers may find
This lady is very eloquent. I'm enjoying hearing her speak.
in terms of when they want the warrants and so on, it may not be easy to access a master. I had thought this problem had been addressed because I had thought a system of emergency masters, just like you have emergency judges, had been put in place for emergency applications like this. Now, it may be that it is no longer in place, but it certainly appears to be a kind of practical solution to the issue which we face. We have also not been told, listen, police officers wanted warrants, let's say on 100 occasions, and they only got them in 10 because they couldn't find a master. So saying that this is what the police want, I mean, I have a lot of sympathy for, because certainly we want to make sure that crime is fought effectively. Who can disagree with that? But it's not just what the police want. Come and tell us, listen, there's a real problem here accessing masters. Has there been communication with the judiciary to see if it can be resolved by having emergency masters? If so, why that is not working? And this is why perhaps we want to broaden the category to include other people. I'm quite happy to agree to broaden that category, as I say, to include everybody else but justices of the peace, because they are unregulated. I forgot to make this point when I was talking about the process used by a police officer who goes acting on instructions sometimes to apply for a search warrant. You go to that justice of the peace afterwards, and you try to find any record of what happened during the course of that application.
You should have heard Xander earlier reading. He was reading. He actually did. Xander did good. He didn't make any grave.
Complaint, another document, and the warrant, and leaves with it.
Xander did much better today at speaking. He didn't make any grave screw-ups, but he was reading very, very slowly.
Say police officer, registration, rank, number, so-and-so came before me at this hour of the night, sought a search warrant for these premises, and it was granted. There is nothing else that the justice of the peace can do. Magistrates, when applications now come before them, in other matters where they still have the power to grant warrants, they very often keep their clerks in the room with them. They keep their note takers with them. So there is a record in the judiciary by the officers of the court, and there's the facility for that. A justice of the peace, if you go after hours, is really a one-man operation. And that doesn't lead to accountability, in my respectful view. It doesn't lead to transparency. But what it can lead to is very dangerously
Corruption.
with no restriction and no protection whatsoever, giving the power to justices of the peace to grant search warrants where they don't even know what the search is going to entail. When I looked at Ajippa as well, I thought, well, how come the police are having this problem? Because Ajippa basically saved those pieces of legislation which allowed justices of the peace.
I'm enjoying this lady. She's actually teaching me quite a bit.
Check, because I
Very
think
well
in
spoken.
high crime, two things which immediately come to mind would be guns, drugs. And that power is still saved. Under the Firearms Act, unless I'm misreading it completely, and under the Dangerous Drugs Act, justices of the peace can still grant search warrants. So how is the police being compromised here? Which warrants are they asking for that they are not getting? I don't like, with all due respect to all of my colleagues in here and to this honorable chamber in which I speak, But I don't like the use of generalizations in terms of somebody wants something, so we've come to Parliament and Parliament should give it to us. That's not why we are here. We are here to scrutinize legislation to ensure that all our rights, because we too are citizens, all our rights are protected. Now, I was so happy when the Honorable Attorney General referred to the case of Central Broadcasting Services Limited. And for the record, I'll give the citation. CV 2019-02135. Now, I will refer to only 2 paragraphs of that case. Excellent decision, because it sets out the history of search warrants and so on. What is intended, what is the purpose, but very importantly, it sets out the difficulty, or it identifies the difficulty that someone being asked to issue a search warrant may encounter. So this is the Honorable Chief Justice speaking in his former incarnation as a High Court judge. And he says at paragraph 33, and Mr. President, I ask your permission to just briefly read it. What all of this points to is that scrutiny of the process by which a warrant has been obtained and the manner in which it is executed is an important safeguard for a citizen in a democratic state. Here, the entity is a broadcasting company, which is accorded legal rights under the Constitution and laws of the country. He then went on to say at paragraph 4,
I hope the Lord puts his hand on Xander.
in a democratic state, the search of a media house can have a chilling effect
Pray for Xander Lee.
on society. The power of search can be used for an illegitimate purpose of intimidating or silencing critics, including invading the privacy of individuals who are present or employed at the media house. A free media operating in an environment, and he continues to talk about the fact that this dealt with a particular right, in this case, freedom of expression stroke freedom of the press. So this case really highlights or makes the point as to why inclusion of justices of the peace in this proposed amendment is dangerous. Because do you really, or do we really expect a justice of the peace with no legal training to say to himself or herself, well, this search warrant has to do with a media house. Now, I must keep in my mind that this has to do with the issue of freedom of expression. Let me see what questions I can ask to make sure that all is well with what the police officer is providing me with.
She's putting up a very cogent argument.
Of the peace, who simply makes us a brief application with 2 recommenders to the Honorable Ministry and then to the President. How on earth will a Justice of the Peace with no knowledge of the law whatsoever even know which questions to ask? And yet we are saying, and the courts have found...
The questions we should be asking is, why does the UNC want to enable justices of the peace to manage search warrants and bail? What is the UNC trying to do? It's like everything that this government proposes, you should question with like...
who do not even know what is the extent of the power that they are exercising when they allow a warrant to be granted. This is what the court is alerting us to. This is the danger that the court identified for us. We didn't have to think of it ourselves. The court, just as Justice Gobin did with respect to bail a couple of weeks ago, the court identified it for us. Now, I also note in a JIPA, and if I may just have one moment here, that section 5 was so very long, it's pages and pages. So section 5A says, where a search warrant has been issued under this act for the purpose of obtaining communications data and so on, and material under the Interception of Communications Act, it talks about what happens where that kind of application is made. So is this amendment in section 10, and I ask the question because I'm not entirely sure, is this proposed amendment under section 10 also going to allow justices of the peace to issue search warrants for material under the Interception of Communications Act? I would think that's in light of all that I have said, I would think that would be an extremely dangerous situation. Now, I know sometimes we come here and we say to ourselves, look, you know, we are part of the Commonwealth. If justices of the peace in other places in the Commonwealth have certain powers and they have had them historically, and it's safe for us. We get a sense of safety from that, saying other countries are doing it and so on. And, you know, it's working for them, so we can follow suit. But in this case, when I tried to do a little dig, I realized that in the Commonwealth, you have a variety of positions with respect to how justices of the peace are created, how they are held accountable, what they are allowed to do, and what qualifications they are required to have. So if you talk about lay justices in the UK, for example, they can even hear and determine cases, but what nobody says or what people forget is they are assisted by legally trained clerks who are lawyers. So they have a support system in the law. So we can't say, look, the UK has lay justices, you know, and they work out fine. So in Trinidad and Tobago, we're not asking for anything too different. Well, I say it's radically different. Jamaica, which was one of the territories cited, Jamaica has legislation.
Testing without the muffle.
Of the peace and holding them accountable in certain circumstances. Guyana has bits of legislation. It's not all in one piece of legislation, but there are bits of legislation which govern how justices of the peace function. So we here, what do we have? We have a work product done by an excellent Attorney General in 1997, which unfortunately never bore fruit in terms of legislation to govern this sector, which we clearly wanted to continue to play a role in the judicial system. So there was no regulation, no accountability, no upgrading in terms of sharing of knowledge, because if you don't even know that a Justices of the Peace Handbook exists, what can we assume that you know about the law which you are being asked to apply?
So since she has the handbook and she knows it's not digital and it's not available online, why doesn't she upload it online for the Justices of the Peace to see? Why is she keeping this information to herself?
The average citizen, let me call my hometown, Rio Claro, Union Village, Manzanilla, in places like those where a police constable is...
You know what, maybe I'll reach out to her because I'm into tech. I'll ask her, I'll offer my services on digitizing that thing for her, the rules.
Vote on this piece of legislation that I have them in mind. Because I certainly cannot, in these circumstances, with all due respect, support an amendment which gives this broad power to justices of the peace. I think with respect to that group or that particular community, and you know, it's not I'm here to throw shade on justices of the peace. They do serve an important function. But I think we are all agreed in here that they need to be upskilled, they need to be regulated, they need to be held accountable. This essentially was what the Honorable Minister of Land and Legal Affairs said in the lower house. So let's not put the cart before the horse. I don't know if, Mr. President, if the Honorable Attorney General will be amenable to this, but perhaps it could be up for consideration. Hive off justices of the peace. Have some means to resolve the issues which the Minister of Land and Legal Affairs told us about. Address it, regulate them, hold them accountable, and then we can have them included or given the kind of powers which we are being asked to permit in this proposed amendment.
That sounds very sensible.
So, with respect to justices of the peace, that is what I would like to say. Now, with respect to bail, I myself only saw it this morning, so I don't want to talk too much about, you know, something that I have not really had the opportunity to look at too carefully, but it seems to me to be fairly uncontroversial. It seems to me that there is some accountability contemplated in the proposed amendment, because I note that one of the subsections says that when the Justice of the Peace grants bail, or if the Justice of the Peace grants bail, there must be some, the person must be taken before a master. So it means that there's oversight. There's oversight. So if a Justice of the Peace uses a land deed which is fraudulent, or takes or doesn't do his recognizance properly, or uses a surety who shouldn't be standing as a surety, then the master oversees that process. I think that is what the subsection is intended to address, and I'm going to take it at face value and say that that is what I understand it to mean. So if that is what is intended, then with all due respect, Mr. President, at this point in time, I don't see how I can have an objection to that aspect of the amendment. So, Mr. President, thank you for the opportunity to speak.
Yeah, Senator Desiree Murray.
Mr. President, I am grateful for the opportunity to contribute to this important debate. Let me begin by welcoming you back to this Honorable Senate. Your presence was missed. But I hasten to add that Madam Vice President exhibited very capable stewardship during your absence. Mr. President, I approach this bill as I do all matters of public policy, from the perspective of a medical professional and an educator, committed to standards, ethics, and institutional integrity. As a senior lecturer at the University of the West Indies, I am deeply invested in the principles of rigorous training, accountability, and the safeguarding of public trust. The Administration of Justice Indictable Proceedings Amendment Bill 2025 comprises only 4 clauses. Despite its brevity, it carries significant implications for the administration of justice and the protection of citizens' constitutional rights. In essence, it proposes to expand the category of persons who shall have and exercise concurrent jurisdiction with masters of the court to issue search warrants. And as per amendment circulated on behalf of the Attorney General late yesterday afternoon, to grant bail in accordance with Section 5(2) of the Bail Act. At first glance, this may appear to be simply a procedural or technical adjustment, but its constitutional weight should not be underestimated. Section 4 of the Constitution of Trinidad and Tobago enshrines the protection of fundamental rights and freedoms, among them the right to liberty.
Why is the UNC trying to impede on your freedoms and your constitutional rights?
The proposed changes to the law must therefore be evaluated not only for their efficiency, but for their impact on our constitutional rights. A search warrant, Mr. President, is not a mere administrative formality. It is a powerful instrument, one that permits the state to intrude into the private spaces of citizens, their homes, and their personal effects. It is therefore essential that the authority to issue such warrants rests with individuals who are properly trained and equipped to exercise that power with the necessary care and judgment. In 2023, this authority was restricted to masters of the court, and with good reason. They are judicial officers who meet the highest standards of legal competence and impartiality. This bill now seeks to confer concurrent jurisdiction on magistrates, magistracy registrars and clerks of the court, and justices of the peace to issue search warrants. While I understand and appreciate the rationale, namely to improve efficiency and reduce delays, because justice delayed is justice denied, I am concerned that without adequate safeguards, such expansion could dilute judicial oversight and risk the arbitrary exercise of power. Mr. President, it is worth noting that magistrates and magistracy registrars and clerks of the court are legally trained professionals. According to the Public Service Careers Portal, which is powered by the Ministry of Public Administration and Artificial Intelligence, a senior magistracy registrar and clerk of the court must be an attorney at law admitted to practice in Trinidad and Tobago. This qualification gives them the legal grounding to interpret the law and uphold constitutional protections. In contrast, justices of the peace, though they perform valuable and often underappreciated service, are not judicial officers. Their qualifications, training, and scope of practice vary widely, and there is currently no uniform framework to ensure consistency in their preparation or accountability. To draw a parallel from my own field, the medical profession, it would be unthinkable, inconceivable, and indeed negligent to allow someone without medical training to prescribe chemotherapy or administer intravenous anesthesia, or to allow an untrained junior doctor to perform an emergency cesarean section. So, professional prudence dictates that authority must be matched to training, competence, and ethical judgment. The same principle applies here. The power to issue a search warrant is much more than a clerical task. It demands not only the ability to read and sign the document, but also
What's
to
that,
weigh
Sadiqa?
evidence,
What is
interpret law, and balance
Srari, what's that?
constitutional rights. Mr. President, this
Ice Way in
not a
America?
critique of justices of the peace. Many JPs serve with dedication, diligence, integrity, and commitment, often in very challenging circumstances. They often provide timely and neutral review of warrant applications outside of regular court hours or in remote areas, functions which are undeniably useful in improving access to justice. However, it is equally true that the existing framework does not guarantee uniform standards of training, qualification, or accountability among justices of the peace. Some are highly capable, but others have entered the office without formal legal education or adequate preparation. Indeed, as my learned colleague, Senator Choate, mentioned, during debate in the other place, the Honorable Minister of Land and Legal Affairs himself outlined several long-standing challenges facing the office of the Justice of the Peace. Among them, the absence of a modern standalone legislative framework, no minimum qualifications for appointment, an outdated and opaque appointment system, no clear age or tenure requirements, weak oversight and accountability mechanisms, no enforceable code of ethics or disciplinary procedures, absence of continuing legal education or training, and limited jurisdictional coverage, particularly
So basically,
in
what
underserved
I'm hearing, what I'm understanding from all of this is justices of the peace should not be involved
Also,
in
justices of the peace
anything
have no
legal.
protection in terms
Like
of
what are they?
governing
Like you just go and with two people and they make you a justice of peace? No,
those are not
that those
minor
people should not be involved in
gaps. They
bail
are
or search warrant
structural
applications.
deficiencies.
Absolutely not.
And they call into question whether the profession, as currently constituted, is ready for an expansion of powers of this magnitude. The systemic deficiencies must be addressed before any expansion of powers is considered. It is worth recalling that as far back as 2001, the Justices of the Peace Bill was drafted precisely to address concerns following allegations of abuse and misconduct in the issuing of warrants. That bill, unfortunately, lapsed in the dissolution of the 6th Parliament. And successive governments
And because
have
they're
yet
not
to
agents
see
of
it
the
through
law,
to completion.
they can misbehave,
We now find
and then they
ourselves
wouldn't have any
in 2025
penalties like
seeking to
actual
expand
attorneys do.
JP authority without
They won't get their
first
license revoked
modernizing
or
the
stuff
legal
like that.
framework that governs
They,
them.
like JP
That,
shouldn't
to my
be
mind,
having this kind
I
of power
agree
in
is
Trinidad.
placing the cart before the
Why is
horse.
the UNC trying to give them that power?
There are also
It's questions you
practical
should be asking yourself.
considerations. At present,
Either this government
there
is
no
incompetent
unified
or willfully
record-keeping
evil.
system to track applications for warrants. A justice of the peace asked to sign a warrant may have no way of knowing whether another justice of the peace or indeed a master of the court had previously refused to sign. This could lead to inconsistencies and undermine public confidence. Mr. President, I am not opposed to reform. I support any measure that makes the justice system more efficient and responsive. But reform must be responsible. Expansion of powers must be matched with training, oversight, and accountability. If we are serious about
I agree.
strengthening the office of the
Incompetent
Justice of the
and
Peace,
evil.
let us begin by passing a modern Justice of the Peace Act. Let us clearly define qualifications, establish transparent appointment and disciplinary procedures, and mandate continuing education. Only then should we consider reintroducing broader powers, such as the issuance of search warrants. I sense, Mr. President, that there is crossbench consensus on this issue. We all want a justice system that is accessible, efficient, and fair, but equally one that is principled and constitutionally sound. In that spirit, I wish to offer practical suggestions for consideration. The medical profession maintains an emergency on-call roster for consultants so that patients have the benefit of their training, qualifications, and experience. A similar system, if not yet done so, could be introduced within the judiciary. Masters of the court could be rostered on an on-call basis for urgent warrant and bail requests. Only if a master is unavailable would the authority then cascade downward to a magistrate, then a magistracy registrar, and only thereafter, if necessary, to a justice of the peace as the last port of call and not the first port of call. Let me be clear, I'm suggesting this especially for emergency situations, which is apparently where the issue lies. An on-call master could readily have dispatched with the granting of the bail in the Joel Alexander case and would have prevented the unfortunate circumstances that followed, as highlighted by Madam Justice Carol Gobin in her 15th October 2025 judgment. Structure would enhance transparency, preserve judicial oversight, and ensure that authority is exercised in an orderly and traceable manner. Additionally, this would ease the burden on JPs, particularly those in Tobago, who must sometimes travel to Trinidad to give evidence in related matters in the High Court. Mr. President, while I recognize the intent of the bill to streamline the administration of justice, I urge that we proceed with measured caution. Expanding the category of persons to issue search warrants beyond masters of the court is not the only solution. I respectfully propose two alternatives. One, an emergency on-call system for masters of the court. My understanding is that there are 12 masters, but it is unclear to me whether they cover the entire country. If nationwide coverage is explicitly granted, this would mean that 2 or at most 3 days per month of emergency on-call would be required. This can be instituted with almost immediate effect. And 2, training, oversight, and legislative reform so that justices of the peace can continue to play a meaningful role within a modernized justice system. The Justices of the Peace Bill should be brought to Parliament for debate and enactment, following which suitably qualified JPs can then be afforded expanded powers. This does not have to be an all or none law. Mr. President, I'll be circulating amendments reflecting my recommendations outlined in my contribution for consideration at the committee stage. I thank you.
Yeah, I'd like to propose that we take the luncheon break at this time. Now it's 12:46. We shall resume at 1:50 p.m. The sitting is now suspended until 1:50 p.m.
All right, that's it. They're taking a break. Renison was supposed to go live. Renison is actually supposed to go live at 12. He has a presentation to do with this Ralph Gonzalez and Anel Roberts thing. I have not heard from him, so I don't know if he's actually going to go live at 12. But we do have a live schedule at 12. I also want to do a presentation on this situation that's going on in St. Vincent. It seems that the Trinidad and Tobago government is inserting themselves into the election process of St. Vincent, and they're sending it the same team of media piglets that they used in Trinidad. They're actually going to send them over to St. Vincent, and I want to highlight that also. So me and Renison are going to do 2 separate streams on this. He is going to focus on Anil, and I'm going to focus on the social media personalities that's going over there to confuffle the minds of the Vincentians. I wonder if I should do it now. Now, you know what? I'll jump off and I'll let Renison come on at 12 o'clock if he said this is what he planned, because he wants to do a presentation for you. So guys, thank you for following, like and subscribe. Welcome to the Slimy Show. Thank you for coming to the Slimy Show. We're broadcasting on Facebook, YouTube on the Slimy Show, YouTube on the Workers' Right platform, our website, on Twitch and on X. Like and subscribe. I'm gonna jump off, and hopefully Renison will come back on in 10 minutes with his presentation. I have not heard from him, so I don't know if he's gonna do it or not. So anyway, guys, I'll see you a little later, and stay tuned for my uploads. I don't think I will go live for the Vinci presentation. I think I'll just do like an off-screen presentation and then upload the video for you guys. Because it's not really for the trainees, it's for the Vincis. Anyway, guys, love you guys.